Welcome to The Explainer. Today we're diving into a landmark 1997 South African Constitutional Court judgment that forever changed how the law views unmarried fathers. It's the kind of case that absolutely forces us to stop and ask some really tough questions about equality, biology, and what it actually means to be a parent in the eyes of the law. So here's how we're going to break this all down today. We'll start with a father's fight, look closely at the letter of the law, and then unpack the equality dilemma. From there, we'll get into the problem with simple fixes, explore some global solutions, and finally wrap up with the court's final ruling. All right, part one, a father's fight, specifically Lori Fraser's battle. You know, behind every massive constitutional ruling, there's usually a deeply human, often heartbreaking story. And this is no different. Let's look at the timeline here. Between 1994 and 1995, Lori Fraser, a system developer, and Adriana Nod, a violinist, were living together as man and wife. But by April 1995, Adriana found out she was pregnant, and she decided that adoption was going to be in the baby's best interests. Well, Lori fiercely pushed back against this. When baby Timothy was born in December, the legal battles pretty much kicked off instantly. But get this, just 2 months later, in February 1996, the adoption was officially sanctioned, and it happened entirely without Lori's consent. No way, right? You have to wonder, how on earth could a biological father just be shut out so completely? Well, that brings us to part two, the letter of the law, specifically Section 18(4)d. The brick wall that Lori ran headfirst into was rooted in a very rigid, almost clinical piece of legislation. It read like this: a children's court shall not grant the application unless it is satisfied that consent to the adoption has been given by both parents of the child, or, if the child is illegitimate, by the mother of the child. That's straight from Section 18(4)d of the Child Care Act of 1983. Notice that incredibly harsh blanket rule there? Basically, if you aren't married, the father's consent doesn't matter one bit. It is completely irrelevant. And we really need to unpack that terribly outdated term they used, illegitimate. Justice Muhammad, who wrote this judgment, rightly pointed out that while the word carries a lot of nasty social stigma, legally speaking, it just meant a child born outside of an officially recognized marriage ceremony. So because Lori and Adriana were never formally married, the law quite literally stripped Lori of his right to consent to, or, veto, his own son's adoption. Which leads us to part three. The equality dilemma. We've got a massive constitutional clash on our hands. So this totally uncompromising 1983 law immediately slammed right into South Africa's brand new constitution. The court looked at this and found that the Child Care Act offended Section 8 on multiple fronts. First, it violated the right to basic equality before the law. Second, it clearly discriminated based on gender, giving the mother automatic rights that the father was flat out denied. It also discriminated based on marital status. And actually, here's the most surprising part, it even discriminated between different types of religious and customary unions. Let's look at a comparison that brilliantly illustrates the sheer hypocrisy that had crept into the legal system at the time. Under the law back then, an Islamic marriage was not legally recognized because it was deemed potentially polygamous. So, an unwed father from an Islamic marriage had absolutely zero rights. But, on the flip side, a black customary union, which was also potentially polygamous, well, that was actually deemed a legal marriage by a completely different law, meaning those fathers had full rights. Treating these two groups so differently was a blatant breach of equality. There was just no logical justification for it. Okay, part four, the problem with simple fixes, or why blanket rules fail. Now, you might be sitting there thinking, okay, this is easy, just cross out the discriminatory words in the law and give all fathers equal rights across the board, right? But Justice Muhammad played devil's advocate here with a pretty extreme but totally vital hypothetical. What if the child is born of rape or incest? Think about that. If every single biological father had automatic legal rights, you would literally be handing an abuser a veto over a mother's decision to put a child up for adoption. So a simple blanket rule, that's definitely not going to work. Or let's consider another scenario. What if the father had a single casual encounter with the mother and has shown absolutely zero interest in the child ever since? Is it really fair to force a dedicated mother to go out and track down a completely absent biological father just to get his permission for an adoption? Again, demanding absolute consent in every single case completely fails the test of fairness. But, we also have to look at the other extreme.
What if the child is 18 years old, has incredibly strong loving bonds with an unwed father who practically raised them, but the biological mother has been completely out of the picture for years? Well, under the old law, the absent mother's consent was absolutely required, but the highly involved father's consent was not. It's crazy. These anomalies perfectly prove that rigid, one-size-fits-all rules just fail to capture the vast, nuanced reality of human relationships.
Moving on to part 5, looking at global solutions. Let's see what international law does here. Realizing that a simple yes or no rule was a disaster waiting to happen, the court actually looked outward to see how other places handled this. In the United States, courts had already started shifting away from pure biology and more toward the fitness of the father. Basically, he has to show he actually provided support. Over in Canada, they require paternity acknowledgement, something like officially signing a birth registry or paying ongoing support. And the UK uses a system of parental responsibility that a father actively acquires via court order or formal agreement. Do you see the common thread here? These nations reward an unwed father's active involvement and responsibility rather than just relying on his biological DNA. And that finally brings us to part 6, the court's final ruling. A very pragmatic solution. Faced with his unconstitutional law and the very real danger of creating a massive legal vacuum, the court crafted a pretty genius 3-step solution. Step 1. Officially declare Section 18(4)d invalid for unfairly discriminating against unwed fathers. Simple enough. But step 2. Give Parliament exactly 2 years to draft a nuanced, balanced replacement law that factors in actual parental involvement. And step 3, this is the clever part, temporarily retain the old law pending that correction. Why? Well, because striking it down immediately would have legally invalidated countless past adoptions, which would have created absolute chaos for families all across the country. It was a really smart move to buy Parliament some much-needed time. Wow, okay, we've covered a lot of ground today. As we wrap up this explainer, I want to leave you with a lingering, provocative thought. How does a modern society perfectly balance the biological truth of parenthood with the complex, messy, daily reality of actually raising a child? The Fraser case is such a powerful reminder that the law absolutely must evolve. It has to recognize that true parenthood isn't just about a marriage certificate, and it's certainly not just about DNA. It's about the responsibility and the lived reality of family life. Thanks so much for joining me today. Keep asking those great questions and keep learning.